Good afternoon, dignitaries, members and friends of PPF Kuwait. I extend you a warm welcome to our legal webinar on Kuwait law updates. My name is Prashant Warrior, Vice President of PPF Kuwait, and I'm honored to be your host for today's event. I hope I'm audible to all. Advocate Rajesh?
Yes.
Okay. The legal system in Kuwait can often seem complex and confusing, and many people may not be aware on the ongoing updates to the law. That's why we have organized this webinar specifically targeted to provide an overview of the updates to the legal landscape in Kuwait. During this session, I expect our speaker, Advocate Rajesh Sagar, to discuss the topic in an easy to understand and accessible form to all. Advocate Rajesh Sagar is a renowned legal expert, and I'm confident that you will find today's webinar, the information shared today, to be both informative and valuable. I encourage you to participate in the Q&A session at the end of the webinar and ask as many questions as you have. We will try to address as many as possible. Thank you for joining us today, and I hope that you will leave this session with a better understanding of the recent changes to the legal system in Kuwait and how they may affect. To kickstart the official proceedings, I now request President of PPF Kuwait, Advocate Thomas Stephen, to deliver his presidential address and introduce our speaker. Over to you, President.
Thank you, Prashant. Am I audible?
Yes, please continue.
Thank you. Very good evening to all, dear PPF members, friends, and well-wishers. Progressive Professional Forum, Kuwait welcomes you all to this webinar on Kuwait law updates. Ours is a group of professionals in Kuwait, including doctors, engineers, lawyers, management and finance experts, professionals, and entrepreneurs. Progressive Professional Forum Kuwait officially launched in the year 2014 with a mission to pool in knowledge, both soft skills, soft and hard skills, and other resources toward inclusive, sustainable societal development. Focusing on this mission, PPF takes up various programs, such as webinars, discussions, promoting online education platforms, project consultation and proposals, scientific programs, and effective interaction with the authorities concerned, whenever there is a requirement of such services, and also does necessary charitable activities to help and support the needy. World Day of Social Justice celebrates on February 20th of every year. The celebration reflects on guaranteeing fair outcomes for all through employment, social protection, social dialogue, and fundamental principles and rights at work. Today's webinar on Kuwait law updates is organized as part of it. And we will cover the work-related issues under the provisions of Kuwait law, labor law, and other relevant laws that influence our life in Kuwait. I just remember my boss always quotes that The law protects both ignorant and knowledgeable, but law neither excuses the ignorant nor favors the affluent. We cannot plead ignorance of law when booked in an offense. Therefore, building up awareness about law or update our knowledge in law is a personal as well as social commitment. Social obligation, I would say. In a holistic perspective, the purpose of law is to preserve and enlarge our freedom. Where there is no law, there is no freedom. Kuwait has a well-structured and well-administered legal system, which is committed to deliver justice to both citizens and residents. While living in Kuwait, we must follow Kuwait laws and rules and acquire knowledge about Kuwait law is helpful to us to lead a peaceful and comfortable life. There are instances when many among us confront with the difficult situations or end up in troubles due to various reasons. For example, some may be out of our wrong notion, ignorance or negligence, or unknowingly we may fall into the trap of someone who wants to exploit us. There are legal solutions in Kuwait to such matters, and we must know the route and method to find solutions to them. We hope this webinar will be helpful to achieve those goals. Having said that, I may move to introduce our webinar presenter today. I believe Advocate Rajesh Sagar doesn't need an introduction. Oh, that's why the webinar protocol. Let me say a few words about him. Advocate Rajesh Sagar is a PPF member and a great friend of us. He is having 25 years of work experience in Kuwait, legal arena. He did his law graduation and post-graduation in Nagam Government Law College, the first and oldest law college in Kerala. He holds an air law diploma awarded by IATA. Currently, he is holding the position as a senior legal advisor to Kuwait Airways company, the national carrier of state of Kuwait. Sorry, NORKA legal consultant to state of Kuwait. And he started his career in Kuwait as a legal consultant with, I think, with the International Council Bureau, a leading international law and a firm of lawyers and legal consultant in the state of Kuwait, representing major, Kuwaiti companies, banks, multinational companies, and later joined as senior advisor, legal consultant with Al Saleh and Partners, another renowned law firm, oldest law firm in Kuwait. And he had got exposure towards the legal, legal arena of Kuwait. And he had also had a good experience and as a practical lawyer in High Court of Kerala. And apart from all this, from his successful legal career, he's a gifted artist. He's a gifted actor as well. He won several awards and achievements while he was studying for his graduation and all. He won the Mahatma Gandhi University Intercollegiate Youth Festival for the one act play. Won first place in University Drama Festival, and a lot of such things. He is a what we can say a multi-talented person, and of course we are proud to introduce him today. And he is absolutely an expert. He was a suitable person to handle today's webinar. And I proudly welcome Advocate Rajesh to this webinar for his presentation. Mr. Prashant, PPS Vice President, is the webinar moderator today, and myself will be handling the question and answer session. I'll be helping out. With the questions we receive. And Ms. Shirley, PPF General Secretary, and Mr. Shankar Ram, our Executive Committee member, are the back-end supporters to this webinar. Once again, I welcome all of you to this webinar, and let's listen to Advocate Rajesh Sagar. Thank you. Over to you, Prashant.
Thank you, President. Now I request Advocate Rajesh Sagar to take over the proceedings. Over to you, Advocate.
Thank you, President, for giving a wonderful introduction. Thank you very much. At the outset, I am saying good evening to all and welcome to this webinar on as a legal awareness webinar. I would like to thank PPF for taking the initiative to conduct this legal awareness seminar and inviting me to present my thoughts and updates on the Kuwait laws and regulations. At the outset, I can say we all know if you are planning to work in any foreign country or live in a foreign country, it is always best to know the local laws and regulations of that country. And if you are going to work there, especially the labor laws and regulations governing the rights and obligations of both employees and employers. In the case of Kuwait, most of the Indian diaspora expats living here are here to work. Very few business people are there, but most of us are working here, and most of them are working in the private sector. So knowing the do's and don'ts in a country will allow us to lead a life with self-esteem, confidence, and peace of mind. Being aware of the laws will always prevent one from breaking the laws and facing legal actions, fines, maybe jail sentence, or even recently we can see a lot of deportations happening in Kuwait. Now, unlike before, they are now taking the deportation decisions within a very, very short span. So it is always very risky if we don't know the laws, maybe unawareingly, we will fall into troubles and we may face legal actions and we may even face deportation, and our career and our life will be in peril. So naturally, we should be aware of the laws. As the President has rightly pointed out, no court or no modern legal system will entertain a pleading that I was ignorant of the proceedings. For example, somebody is bringing drugs to Kuwait, and if he is caught at airport, he cannot claim that, I was under the impression that the drugs are allowed here, like some states in US. So nobody will listen to that kind of explanations or excuses. So it's very, very important to know what we can do and what we cannot do in this country. So, many of the expats, especially the Indian diaspora living here, they're all under the impression that Kuwait legal system is completely hostile and alien to them. And it is devised and developed and implemented only for the benefit of Kuwait nationals, which is absolutely a wrong perception or wrong understanding of the legal system. Actually, Kuwait follows civil law system. Civil law system, basically we can divide the legal systems of various countries in two categories, which is civil law system and common law system. Most of the British ruled countries like India, Australia, America, we all follow common law system. But Kuwait follows the civil law system since we know the Kuwait laws are basically derived from the French legal system, which is predominantly or which is a civil law system. And also, while saying that the Kuwait has derived the legal system, the basic structure from the French legal system, it has elements or it's a mix of French law system, British law system for commercial laws, because most of the contract laws and business laws all over the world are predominantly devised and developed by the British. And then also in Kuwait, they are also following the Egyptian legal system, because Egyptian legal system also derived from the French legal system, because they are all ruled in this part of the world. Most of the countries are ruled at some point in time by the French. So that is why the French legal system has a dominance in this part of the world. So Kuwait legal system is largely secular. Sharia law governs the origin of the law, most of the laws, but predominantly it is Sharia law is governed or applicable for the family laws. That is also for the Muslim residents. Basically, non-Muslim residents, we can opt for a secular court, which we have. Basically, the personal laws are considered by three kind of courts. For Sunni Muslims, there is a Sharia Sunni court, and then Shia Muslims, there is a Shia court, and then for non-Muslims, there is a secular court. So this is the only case where the Sharia law has any relevance in the Kuwait legal system. It's only applicable for personal laws. All other laws are secular, and procedural laws are very well in place. And we can say that Kuwait is one of the oldest organized and modern legal systems in the GCC countries. Kuwait has introduced all these laws almost since 1960s. But countries like UAE, Qatar, which we think as modern countries in or progress countries in GCC, they all introduced these kind of modern legal system very lately. So compared to all other GCC countries, Kuwait legal system is one of the oldest legal systems, and having procedural laws in place, and it's secular, and it follows principles of modern law, like principles of natural justice. All these things are very well applied in the Kuwait legal system and procedural laws. Kuwait constitution is the basic fundamental document, same like in India. The constitution, all the laws are actually connected or derived from the Kuwait constitution, which is largely secular. And then the judiciary in Kuwait is also independent, and it is structured in three levels. We can say three levels means the first degree courts, the appeal courts, and the cassation court. When we compare it with the Indian system, we can say the magistrate and civil sub courts at first level, or municipal courts, and then we have high courts and we have supreme courts. So here the high courts in Indian system is equal to the appeal court here, and the Supreme Court is equal to the cassation court here. Cassation court rulings are final as far as a particular litigation is concerned. Same in India, Supreme Court rulings are final. But unlike in India, Kuwait, since it is a civil law system, it may not follow the precedents except in very few cases. But in India, naturally, we all know that Supreme Court has ruled in a particular subject. The courts below is bound to follow the principles laid down by the Supreme Court when they are considering similar cases. So, as I mentioned, we most of us are working in Kuwait, and most of us are working in private sector. Probably we are all interested to know what is the law governing the work environment in Kuwait. So maybe we all know that the largely the segments are divided into three categories. The working segment. The first one is the private sector, which is governed mostly all of us are under Article 18 visa. Article 18 visa means we are all working in private sector, and we are governed by the private sector labor law. And those who holds Article 17 visa means that they are all working in government sector, or they are governed by the government sector labor regulations, which comes under the Civil Service Commission. And then there is a third category, which is called domestic workers under Article 20 visa. They have a completely different set of regulations. Until recently, there were not even any regulations for them. But recently, the Kuwait government has considered this this issue due to pressure from international community, international labor organizations, and many countries, including India. that the domestic workers' rights should be protected, and accordingly, they have recently Kuwait government has made many legislations and arrangements to redress the grievance of domestic workers also. But still a lot of work has to be done for in that particular segment. But it is continuing. It's a continuing process, and we hope that in future the domestic workers' rights also will be protected equally like the private sector workers in Kuwait. So let's talk about more about the private sector labor law, and then maybe we can touch base some other um, laws of importance or laws of interest for the expats. So the private sector, when we talk about the private sector labor law, the 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 previous labor law was enacted in 1968, and then it has been there for a long time. There were lots of complaints about that previous law. So the Kuwait government has been considering to revise and introduce a new law for so many years, and finally, in 2010, the Kuwait Parliament has passed the new labor law, which is existing now and which is applicable for the workers or employees working in private sector, which is called Law Number 6 of 2010. And there were some subsequent amendments to the 2000 law also, 10 law also, which came in 2017, and then Public Authority of Manpower, which is in short called PAM. They are also controlling or regulatory authority in the labor field now, because this is also created. This Public Authority for Manpower was also created pursuant to the introduction of the labor law in 2010, because all the regulatory work is to be done by this Public Authority of Manpower. For example, the visa residence transfer regulations are updated and announced by Public Authority from time to time, depending on the labor market requirement and various other conditions. So the 2010 law introduced major changes to the working condition and rights of the employees in the private sector. That we can check few of those salient features of the new law, and then when we go to the next session, which is the question answer session, probably through while answering the questions, more and more clarity will be given to those important points which are directly affecting the interest of the workers in Kuwait. See, the one of the major change introduced by the new law is on the probation period, probation, and also on the first we will talk about the written contracts, employment contract. During the previous the labor law era, the written contracts are not that mandatory, but subsequently after the introduction of 2010 law, written contracts are mandatory and it has to be filed. Moreover, the Public Authority of Manpower has introduced a standard format. So earlier this issue was each employer will have different set of contracts, and then employers are not aware of the standard conditions to be included in a work contract. So many companies or many employers were using this gap and trying to exploit the workers by not including many important points, and when a dispute comes, this contract is silent or having non-comprehensive contract, then that will create a problem to establish the employees' rights. So considering this issue, the Public Authority Manpower has introduced a new format which all the employees has to follow while submitting uh, the application for the work permit, for the issuance of the work permit. So which actually help the employees' rights, because now at least we can give awareness, we can give knowledge to the employees that, see, this is the contract you should sign, and when if an employer is giving a different document, always the employees can say that no, we have to include this, etc. Basically about the leave, about the salary, about the termination rights, these things are included in the contract, which the format is available in the Public Authority of Manpower website. Anybody can go check it, and it's available in the different websites online also. So it's easy accessible. So anybody who wish to come to Kuwait and work in Kuwait can always check this document well in advance and then negotiate with the employer while signing his job offer or employment contract. So which is actually a good change compared to the previous period. Then we are talking about the probation period. Probation period, earlier it was not exactly defined, but now the new law is very clear, very explicit on the number of days an employee should complete during the probation and the rights of both employee and employer during the probation period. Now it is 100, it's fixed as 100 days maximum. If an employer wishes to reduce the period, there is no problem. He can make it 60, maybe 30, it's up to them. But he cannot increase the probation period for more than 100 days. And also, an employee should not put into multiple probation periods during an employment with the same employer. So this is also very, very important. Even if he is changing the title without terminating the service, he cannot put him again on probation. But if his contract is terminated, his settlement is done, and if he is reappointed to a new post, then it's another issue. A new probation period can be implemented for that particular uh, post or a job. Then also the rights of women employees are also considered, and many provisions have been introduced to protect the rights of women employees. There were some discriminations before, but now the discrimination is no more there. Equal pay for equal work. Even if somebody is working the same post, a lady employee and a male employee, then both should be paid equally. This is a new um, clarification or new uh, provision introduced by the labor law. Plus, the maternity leave provisions also been um, interpreted in favor of the women employee, because in old law, if suppose the women employee is taking maternity leave in a particular year, she cannot avail the annual leave together with that, or that particular year annual leave is counted as part of the maternity leave. But the new law has separated that. Even if she is availing a maternity leave, annual leave can be taken separately. Plus, they are getting a 2 hours exemption to feed the baby up to 2 years. This is also a new regulation. New law has introduced this provision. So see, like that, many things have introduced to help the rights or help the encourage more and more women employees to come and join private sector, from both from expat side as well as from the Kuwaiti side. And then we can talk about the annual leave. The earlier law provides 14 days annual leave for the first 5 years for each completed year of service, and then 21 days for each completed year of service after 5 years. But the new law has changed that system. From the very first year, employee will get 30 days paid annual leave. And moreover, there are some other changes also came in 2017, and even Public Authority for Manpower also in 2021 introduced some clarificatory note saying that how the annual leave should be calculated and which days should be counted for while an employee is in annual leave. Earlier, public holidays and Fridays were excluded when the new law was introduced in 2010. 30 days shall not include Fridays as well as public holidays. But the 2017 amendment introduced a new provision which says that if an employer is following 5 days week, then he is not supposed to count Saturday also while counting the annually. But there are a lot of objections, and from the business community here, they are saying it will increase the liability of the companies. So most of them are not holistically following this particular provision, but some companies have already introduced and adapted this situation also. And also, when the law came in 2010, when an employee is joining first time with an employer, he has to complete minimum 9 months to get paid annual leave. But the 2017 amendment has changed that. And even the Public Authority for Manpower decree came in 2021, also reiterated that position. Now, as per the new situation, if somebody has completed 6 months continuous service with the new employer, he or she can avail paid annually. So this is also a major change. Then now another major change introduced by the new law is the termination notice. See, earlier it was 14 days termination, 15 days notice was enough to terminate the service of an employee. Vice versa, if an employee can also resign with 15 days notice. But it was so harsh and it was so difficult especially from the employee's perspective, that suddenly an employee is terminated and he is only given 15 days. It's so difficult to find an alternate employment or make arrangements to leave the country after disposing of his assets. Maybe his family is here, his children are studying. So it's very, very short period. And many employers were abusing this particular provision to pressurize the employees by issuing sudden termination. So the legislators have considered this the hostile provision, and then they have changed it. Now, as per the new regulation, it's mandatory to give 3 months notice to terminate an employee from the service, except with there is a 2-3 situations where an employer can terminate the employee without notice and without notice pay or indemnity. That we will talk later. But in normal scenario, normal case, an employee or employer, either way, to terminate service should give 3 months notice. One more provision, one more exemption is given if both are in agreement, employer and employee in agreement. Then if suppose an employee is resigning with the 3 months notice, but he needs to join another company in short notice, he can negotiate with the employer, and if the employer agrees, he can compensate the remaining period and he can leave the company early and join the other one. Likewise, the employer can also ask the employee to stop working immediately, provided he should pay the notice pay in lieu of that notice pay in lieu of the notice period. So he has to pay 3 months salary, and then he can tell the employee not to come and work. So if employer terminates the employment, employee will also get a benefit weekly. One day he can leave early to look for alternate employment. Maybe 2 to 3 hours exemption should be given in a week at one day to look for alternate. These are all changes which nobody was even thinking of before 2010. So these changes have actually changed the color of the labor legislation in Kuwait. And because earlier many international agencies, human rights associations, ILO, they were all complaining about the hostile provisions in the labor law, which now with the new changes and ongoing changes, we can say that the Kuwait labor law is up to the modern, at par with the modern labor laws prevailing in other countries, other modern countries, or other refined legal systems, so-called legal system. So we can say these kind of provisions have changed the working condition, the peace of mind of the employees, the self-esteem of the employees, so the self-confidence. These are all there, but at the same time, if we don't know about these provisions, these rights, what they will do when a situation arises, the most important thing we should do is we should know what is our right, an employee's right in this particular situation, and then what are the options available for us to enforce these rights. And the timing is also very important, because when we are issued with a termination notice, and if the employer is forcing us to exit the country, then we should approach the authorities, Ministry of Social Affairs, without losing much time. But that, because the proceedings will take some time, and we have to compensate that time before we transfer and join another employer job. So these things are very important. So that is why these kind of seminars will help us to understand what are our rights and what are the provisions available, what are the channels available to enforce these rights. So now we talk about another important point under the labor law, which talks about the terminal benefits. See, the old labor law was not that much flexible when we talk about the terminal benefits, especially when an employee resigns from the service. The new labor law provides that if somebody has completed at least 3 years of service with an employer and he resigns, that means at 3 to 5 years, then he is eligible for half the indemnity as guaranteed under the labor law. And if he has completed 5 to 10 years, he will get 2/3 of indemnity, and above 10 years, he will get full indemnity. This I'm talking about the resignation by employee. But in case of termination by employer, whatever be the period, the employee is entitled for full indemnity, and there is no deductions are applicable, except in very few cases. And even regarding the overtime also, see, many of the employees may not aware that there is a capping, or there is a ceiling on the the overtime. See, people cannot work more than 2 hours in a day, and there is also a total capping, which is 36 hours. That is a normal the reduced working hours during Ramadan. Even during that period also, the overtime should not exceed 2 hours. So that should be known, and most of the people are not aware that if they work on a public holiday or on a Friday, the double the overtime they are eligible. So these things they should know when the employers are deploying them during these days for additional work. And also the medical leave scenario also has changed. Earlier, the medical leave was not like the latest law. Which now what they are providing, what the labor law is providing, is 15 days in case we met with an accident or there is an issue, sickness. Then we are eligible for 15 days with full pay, and then 10 days with 3/4 pay, and then next 10 days with half pay, and then 10 days with 1/4 pay, and then the 30 days we will get without pay. So this is the maximum. And if we are not able to recover from the illness, or we are not fit to work after these exhaustion of all these leaves, then probably the employer can terminate us by paying us with full indemnity. Including this leave period we have taken will be counted as part of the service also. And also the number of national holidays has also increased in the present labor law. So that also is a change. Before it was 9 days, now it is 13 days. So there is a increase of 4 days holiday. And why the increase in holidays are important? Because anyone who works in these days will get double the overtime, and also a compensatory off in addition to the overtime payment. So this also is as a major change. And then dispute resolution mechanism has been refined, and it's more efficient, and people are it's easy for the employees to approach the different governorates where the Ministry of Social Affairs offices are located. You can file the case, and even translators are available now for the foreign workers who is not aware of the Arabic language, because that was a barrier before. Those who are not familiar with the Arabic language finds it very difficult to go and comply and establish their rights. So that is the reason. So we can say that the new law has introduced major changes in the working atmosphere of in the private sector. When we talk about the government sector, I told you this is totally different, because the civil service rules are completely different from the private sector labor laws, which each ministry has got its own specific rules. For example, MOH, the nurses, in the nurses case, some of them are not getting maternity leave even during the pregnancy because of the emergency nature of work. So there are so many other factors which are totally different from the private sector. Some factors are better than the private sector labor law, but the new labor law has almost bridged the gap. There is not much difference between the benefits given under the civil service regulations as well as the private sector labor law. I think with this note, I think we have to end the first session. And now, if we will answer when we go to the question answer session, which is then we can elaborate on some other provisions of law and some other practical situations which will be beneficial for all. And I encourage people to utilize the Q&A because that is more beneficial and interactive and more live. So I request all of the attendees to come forward and ask their concerns or their questions without any without any hindrance. So, and I hand over the mic back to Thomas to present the questions gathered from the members. And I will try to answer, the generic questions. I will answer directly here. And if any questions needs further specific research or need further information, I'm always available and I can answer to them one-to-one. Some questions are very, very specific and personal. Those questions please avoid. Probably that can be discussed separately and answered separately to the individual concerned. Thank you very much once again, and I hope we will conduct these kind of seminars in future also, which is always beneficial to the community. Thank you very much.
Yes, Mr. Prasad, shall I take over?
Yes, President, continue.
Okay. Thank you, Rajesh, for a summary presentation and specifying the updates and all. And let's go into the question answer session. We got a few questions so that I can share with you. I mean, almost nearly 40 numbers of questions are there. I don't know whether we will get enough time to cover all those questions. Anyway, we will try to.
We'll try maximum.
Yeah, we will try to. Do justice to the people who ask that question.
Yeah.
Anyway, yeah. Let's start. I have. Categorize the question into several, topics: general, labor, personal, like that. Let me see. So there will be some questions which is having a representative nature that is compiled, and I have put it in a reshaped in a manner so that you can understand. Let's start. So first, just want to ask you something about the engineers problem. What is a hot topic in Kuwait?
Yes.
The question is regarding that it is affecting their job status and other residency privileges and all. And what exactly do we have a legal solution to that? Whether that matter can be legally contested in Kuwait, or what exactly, or it is remain as an executive issue?
See, Thomas, this I'm getting these questions repeatedly from our friends, engineers friends. But the first thing we should understand, or we should, when we approach this issue, the most important issue is this cannot be resolved through by filing a case in Kuwait or in India, because this is an administrative or policy decision. But it can be resolved through effective coordination between the authorities in Kuwait, the relevant authorities in Kuwait and India. And a candidate cannot object or deny complying with conditions or regulations implemented by the relevant authorities or bodies in a country to regulate a particular quality of a particular category of job. So similar conditions are already being implemented for other type of jobs, for example, the nurses, doctors, etc. But the key problem here is there are some discrepancies. When basically largely this issue is related to the Indian part, because we cannot say that this particular requirement is applicable only for Indians. No, this is applicable for all engineers. But the other countries' regulations probably may have one uniform set of accreditation or procedure. But in India, unfortunately, we have different sets of accreditation formalities. Even if we go with one thing, few people are still affected. If we go with other versions, still a group of people are affected. So naturally, we should resolve it through the Indian authorities, and they have to generalize or regularize or introduce a uniform system wherein all the engineers passed out of Indian universities or colleges can comply one set of common rule. Because and then inform that to the Kuwait Engineers Society, they will also be ready probably, because see, at the end of the day, the labor market, job market in Kuwait largely depend on engineers from India. Without engineers from in India, no major projects can be executed. So they are also interested to resolve, but the solution is still not coming. It's a very gray area. So the answer to the question directly, we cannot resolve it through filing a case, court case, or challenging it before the authorities, because it's predominantly a policy matter, an administrative matter, which cannot be, contested.
Okay, thank you. So next thing is, since you are, legal advisor to the NORKA and providing services, can you little bit, summarize what is the type and extent of the legal services provided through this?
See, this particular scheme, the legal aid cell or legal aid scheme, has been introduced by NORKA 2-3 years before, based on repeated requests from various parts of people, various parts of the NRKs living outside India. See, we have also raised these projects to Indian Embassy. Maybe Thomas is aware of that, because we as a lawyers forum have given representations to the Indian Embassy to organize such a scheme. But unfortunately, the scheme introduced now is not meeting the actual needs and requirements of the people. Similarly, various representations were given to Government of Kerala to protect the interest of NRKs living outside India. The key issue is the main purpose of the scheme is to imbibe legal knowledge to the NRKs, because once we know the legal issues or legal situation in a particular country, that itself will give a preventive thing, because if you know a particular thing cannot be done, then at least we will not enter into that situation. So it's larger, mainly preventive, and also preventive advice, legal advice. This is the only, because we have limited resources available. So if somebody is facing a problem, we encourage them to contact us in advance to formulate appropriate strategies or take timely measures, not to escalate or aggravate it. So, it's mainly advisory in nature, but mainly this advice is intended for labor disputes, small time issues and all, but not for major criminal matters, money or commercial disputes and all. This is purely personal issues which has to be conducted separately, and which is not coming under the purview of the scheme. Plus, we are also trying to conduct legal awareness seminars in cooperation and coordination with various social organizations in different respective countries, which will largely help people to avoid issues. So this is a larger scope of the scheme. But anyway, this is a beginning. Probably we can expand the scope, when time comes and resources are available.
So, okay, fine. Then I think let us go to the labor laws. A few questions are there from that. One is that if we have an employment bond with a company, is that legally valid as per Kuwait law? Are we eligible to get a release if we approach Shun office?
No, the simple answer is, in Kuwait, I told before also, it's a civil law system. Once you sign a document committing something, the courts will not go beyond that document. So if the employer is presenting that document, the presumption is the employee has signed the document with his knowledge of the liabilities he is going to face in case he breaches the document condition. So naturally, if a bond is to be signed, employee should take all precautions while signing the bond. If he is not able to, comply with the conditions, then better he should not sign. If he's signing a document, then naturally that will be binding on him. Except in case where he's signing some illegal thing. Illegal
That
thing
is,
means he has committed to
yeah,
do some illegal activities.
anything contradicting the labor law
Contradictory, yeah,
provisions?
correct,
Yeah.
correct.
Okay, fine.
Suppose the employer is pushing him to do some illegal activity, and then naturally that will not be binding on him.
Okay.
Otherwise, it will be binding.
Okay, fine. Does long years of employment in a company sponsorship allows an employee to transfer to private visa? I mean, generally there is 3 years period is there. So is
Yeah.
still that period is valid, or how it is?
See, the thumb rule or default rule is 3 years when he comes first time to Kuwait and to join an employment with an employer. Okay, this is the first time employees. Somebody is coming recruited from overseas, and then he comes and works here with an employer. Then for the first time he has to complete 3 years. But recently, Public Authority for Manpower (PAM) has announced an exemption to this, saying that if an employer agrees, then he can be transferred after completion of 1 year. But that is subject to agreement of the employer. If employer is not agreeing, and if he is intending to get a contested release, then a 3-year period is mandatory. And for local transferred employees, 1 year is enough.
Okay, fine. That's fine. So what are the conditions to satisfy the transfer of project visa to company visa or visit visa to, job visa, 18 number visa, then possible to transfer the domestic visa and the dependent visa to 18?
Okay.
Now,
See, first we will talk about the project visa. As of now, as per the latest position, project visa can only be transferred to another project. Or if the same employer is getting another project, it can be transferred to the other project also.
okay.
But with an exemption, suppose an employee came to Kuwait under normal Article 18 visa, and after some period he got transferred to a project visa. In such cases, his original visa is not project visa. His original visa, if you see the work permit, you will see the original project visa number or original visa number. If that is 18, the normal 18, he can go back to the normal 18 visa. But if he comes under a pure project visa, he can only be transferred to a project visa. So this is related to the project visa situation. And then we talk about the other two situations. Other two situations, default rule is no. You cannot transfer what you call Article 20 visa to Article 18 or Article 22, which is dependent visa to Article 18. But the Public Authority of Manpower opens window on a shorter period depending on the labor market condition in between. During that exemption period, maybe last year, I believe after the COVID, they have opened transfer of domestic to work and dependent to work visa for a particular maybe 3 months up to 4 months they have opened. During that window, you can. Once it is transferred, then it is easy to transfer back and forth. It is not a problem. Not for the domestic, for the dependent and work visa. Once you transfer from the dependent to work, then later you transfer back to dependent also, you can transfer back. But domestic, no. Domestic is only allowed during that particular period.
Good. Okay, fine. So another question is, what is the general procedure of filing a complaint in a SHU? How many hearings will be normally there? And what if the opposite party is not turning up?
Okay. See, the SHU, first of all, we should know where to file. Because suppose my visa file is in Ahmadi Governorate, for example. Then each governorate, there is a dispute resolution department under the Ministry of Social Affairs, which is called SHU generally. So you should know where to complain. Suppose your visa is under Ahmadi Governorate, you should go and complain at the Ahmadi Governorate dispute resolution. There is a particular department. You can go and file a complaint. There will be typing centers. They will help you to type the complaint. What is your complaint? Then you type that and then file it. Then once the complaint is accepted and registered, they will issue a pink slip, which gives you the proof that you have already filed the complaint. And then later, nowadays they are sending the appointment by SMS. So you will get now the complaint filing is also online. That is also I forgot to tell you, after the COVID they made it online. So online we can get a username, password, then you enter and then you file. Then once the complaint is accepted, you will get a confirmation, and then a hearing date will be decided by the authority, by the shown. And if you have given the right address and contact numbers of the employer, they will contact the employer, and the employer is supposed to appear before the shown on that particular date. Suppose the employer is not cooperating. So now at present, they are giving at least 3 hearings opportunities. So after the 3rd hearing, if the employer is not showing up, naturally they will proceed and take a decision ex parte.
Okay.
So if an employee is eligible for a release, they will issue the release directly without the employer's consent, provided the employee should provide the original passport to process it. If the passport is not there, then the process will be delayed.
Okay. So in case of any dispute regarding the payment and all, that is indemnity
No,
or
the
something?
payment issue is different. Payment issue will never be finished at the shoot. What they will do a conciliation process only for the payment matter, in settlement of indemnity, any outstanding payment due to salary dues to the employee. What they will do is a conciliation process. But for the visa transfer, the shoon is the final place. So there is no need to go to the court. But the payment money related issue, what they will do, they will try to do a conciliation. If the conciliation fails or the employer is not cooperating or refusing to pay, they will wrap up the matter. They will send it to the court. So then the court will consider the matter, and then court will issue an order.
Right. Right. So another question is a private sector, healthcare employee.
Yeah.
After 4 or 5 years of service, she wants to join with another employer.
Okay.
But his present employer, do not want to release her.
Okay.
At the same time, he is threatening her that he will, cancel her registration. Of this healthcare people requires a registration with this one, and he is threatening her that he will cancel that one. So is this this registration is transferable to sponsors, and what is her remedy on this?
Okay, these medical professionals, unlike other professionals, there are 2 things attached with their employment. One is the residence work visa or residence visa, we can call this. The other is the license to practice or medical license. So this medical license is, I believe, this question is mainly related or aimed at the medical license transfer issue. So if a nurse has completed, a medical professional has completed 3 years after coming first time from India, for example, and then if she has completed 3 years, she will get, she is eligible for a visa transfer through Ministry of Social Affairs. So she has 2 avenues to go. Right. One is to go approach the Ministry of Social Affairs to get the visa transfer, which most of the cases she will get, because if she has completed 3 years, naturally she will get the visa transfer. Then regarding the medical license is an issue. Medical license, unlike many people think, the license is not in the name of the individual. It is actually issued in the name of the clinic or the hospital where she is working. So it's a joint issue, joint thing, because naturally the employee has to write the exam, attend the interview, pass it, and then only the license will be issued. But the license is issued for the benefit of the hospital or the clinic she is working. So the owner of the license, largely we can say the clinic, because if the clinic is not having the proper license, this particular license will never be issued. So they will keep it. Okay, suppose the clinic is agreeing to release the license, issue is very simple. She can join the other employer and she can transfer the license to the new clinic with the permission of Ministry of Health licensing department. But if the particular clinic is refusing to give a release of the medical license, the option available to the nurse is she can get the transfer of the visa. That's one thing. Then she can approach the Ministry of Health, the licensing department. There is a legal department. She can go and file a complaint with the new clinic, and they will examine the matter. There are 3 conditions, I believe, they will consider. And then according to their discretion, they can transfer the license. For example, if a nurse is working in a particular governorate, they will not give transfer to the same governorate.
Okay.
So if she is joining another clinic in a separate governorate, they will give, and she has to complete minimum 3 years with the previous one. So there are 2-3 conditions. If they are satisfied with these conditions, they will transfer.
Okay. So in short, we can say that this transfer of registration is a case-by-case manner. They
Case
will
by
look
case.
at whether
Yes.
the criterion is satisfied, it will be done, right?
Correct.
Okay. Great.
But
Another
always
question.
better to keep at least a copy of the license. It's many cases even the nurses, they don't have a copy of the license. So it's always better to at least to keep a copy.
Okay, fine. Another question is that one of the employee want to transfer his residency to another company, but the company's file is closed and he is not in a position to transfer his ICAMA to the new company.
Okay.
If he got an extension of 3 months during this time, and it is going to expire within 10 or 15 days. He just want to know, as per Kuwait law, what can I do to transfer my ICAMA to another company in this scenario?
See, in this particular case also, public authority has issued clarifications. Because if it depends, largely it depends on what is the reason for cancelling the license, the file of the company. Why their shown file is blocked. There are various reasons, but there were some companies, they have blacklisted completely who were involved in the visa trading. There are around 40-50,000 visas, company files, visa files are blocked because of this trading. And they will only consider case by case. So we cannot say as a thumb rule, you can go and get a release. No, the thumb rule is no more release, you have to go back. But in some cases, we can approach the court, file a case saying that the employee proved the innocence because on humanitarian grounds, maybe he is a professional, probably his family is here. So each case by case, the court may issue also a decree directing the Ministry of Social Affairs and Immigration Department to facilitate his transfer. But it is purely a case by case thing. And during some period after COVID, the public authority has opened the window to transfer these blocked files to new employment depending on the labor market requirements. But that is closed now. Okay,
fine. Another question is that if a person is on 3 months notice period, I mean, the company says that they will not pay the salary during this 3 months. The salary will be paid only after the completion of these 3 months.
No, that is not correct.
Legal? Is that legal?
No,
yeah,
that is not
correct.
It is
against the provisions of labor.
Yeah. See, exactly the intent of the legislator is to protect the interest of the employee. So they can only they have only 2 choices. Either they have to pay upfront and ask the employee not to come for work. This is one option available to them. Other option is they have to pay regularly as in a normal way till the completion of the notice period. So if they are not paying the salary, immediately you can go to the show.
Yeah. Okay. Another question is, husband asked this question. His wife had to exit from Kuwait due to medical reason, that is pregnancy issues, and she has stayed more than 9 months in India. Now, can she come in Kuwait in new visa? Is her visa blocked? What need to be done in such case to issue new visa?
Visa blocked, I don't understand, because now especially they have reintroduced this 6 months period.
Yes.
They have from February, they have introduced this new again. The 6 months period has come into force. So if you cross the 6 months,
there was a cutoff time given by the government to come back on that time.
Correct,
if that,
correct.
Is,
if that is not there, then her visa is considered as cancelled.
Right. Then she has
they
to
can apply for a new visa. They can apply for new
or
visa.
dependent visa.
Yeah.
Okay. Thank you. Then next question is, if an employee joined to a new company, but the visa is not a transfer to the new company. During that time, if the employee expired, either during the work or not at the work, then which employer will be responsible to provide his insurance, where he is absolutely
First of
having
all,
the insurance?
there is no, if it is a natural death out of work, no insurance is available. This is one thing. If it is during work time, employee died at the new employer's side, the new employer is, because it's a workman's compensation thing. But it's a natural death, the responsibility lies with the old employee or old employer to send back the, the human remains to the back to the home country. But it depends largely on the documentation, because if there is a clear document proving that the employee has released completely from the files of the previous employer and he has already joined with the new company and he has processed the transfer, then it's new employer's liability, or it depends on the exact situation. But we can say if it is an accidental death during work in new employer's premises, it is new employer liability, no doubt about it.
Okay, fine. Does the employer has the right to hold the employee's passport?
No, because even public authorities new regulation, which I think section 38, I believe, article 38 of 2021 ministerial decree clearly bans that employer cannot hold passport of employees. But in all practical sense, employers are very conveniently keeps the passport, saying that we are keeping it for safe custody.
Yes. Another question is that does the concept of the principal employer in law is there? Because in the case of secondment, I mean, several work contracts are with the K companies.
See, that is a very gray area, because
whether these K companies can be considered the principal employer and the to the supplier on the contractor for not complying the labor law.
I will tell you.
Is that question clear or no?
Yeah, I know. Because the problem here is very few companies are having the manpower supply licenses. If those companies are supplying, it's a different issue. But most of the secondment contracts are subcontract agreements for services. So there, the other company is only a client, and the actual employer is the employer who is giving service to the other company, not clearly mentioning in the contract that these are employees are working for them, but it is termed differently as a service. So they are undertaking some service to be provided, and to provide that service, these employees are deployed or deputed at their premises to do the job.
Okay.
So definitely accident cases, again, the principal employer or the one who is controlling the work site will be responsible, but the ultimate liability lies or rests with the actual employer under whom the work permits are issued.
Okay. Another question is that one person wants to make a global app. That's what he says. I mean, for regarding the making payment through the app. So he may be
first of all, I know I got the point, but if the server is placed in Kuwait, he has to go through all the approval process. But if the server is situated outside Kuwait, something else. But still, the liability he is answerable if he is present in Kuwait, and if a customer goes and complies to the ministry, then naturally he is in trouble.
Okay. I mean, can you a little bit explain in Malayalam regarding this indemnity and whether it is applicable to 20 category? Are they entitled to get any benefits like that in Malayalam?
ഈ 20 കാറ്റഗറി വിസ എന്ന് പറയുന്നത് നമ്മുടെ ഇപ്പോഴത്തെ ഒരു സാഹചര്യത്തിൽ പുതിയൊരു റെഗുലേഷൻ വന്നിട്ടുണ്ട്. ഇന്ത്യയുടെ കേസിലാണെങ്കിൽ ഇന്ത്യയും കുവൈറ്റുമായിട്ട് ഒരു MOU സൈൻ ചെയ്തിട്ടുണ്ട്. ആ MOUവിനെ അടിസ്ഥാനപ്പെടുത്തിയിട്ടാണ് ഈ ഒഫീഷ്യലി ഒഫീഷ്യൽ നമ്പർ 20 വിസ റിക്രൂട്ട്മെന്റ് നടക്കുന്നത്. ആ MOUയിലുള്ള കണ്ടീഷൻസ് കംപ്ലൈ ചെയ്തിട്ടാണ് Indian embassy has to approve the അവരുടെ കോൺട്രാക്ട് അപ്രൂവ് ചെയ്യണം. അപ്പൊ അങ്ങനെയുള്ള കേസിലെല്ലാം ഒരു ഇൻഡെംനിറ്റി പോലത്തെ ഒരു പേയ്മെന്റിനുള്ള ഒരു പ്രൊവിഷൻ ഉണ്ട്. പക്ഷെ അപ്പോഴും ഉള്ള ഒരു പ്രശ്നം അത് എക്സിക്യൂട്ട് ചെയ്യാനുള്ള ഒരു ഫോറോ കൃത്യമായ ഒരു ഇപ്പം പ്രൈവറ്റ് സെക്ടർ എംപ്ലോയീസിന്റെ കാര്യത്തിലുള്ളതുപോലെ ഒരു സിസ്റ്റം ഇപ്പോഴും ഫുള്ളായിട്ട് വന്നിട്ടില്ല. അതുകൂടി ഇംപ്ലിമെന്റ് ചെയ്ത് വന്നാൽ ഈ സാധ്യതകളുണ്ട്. എന്നാലും പഴയതിനേക്കാൾ ഒത്തിരി വലിയ ഇംപ്രൂവ്മെന്റ് ഉണ്ട്. കോൺട്രാക്ട് ആണ് പ്രധാനം. പിന്നെ അൺഫോർച്ചുനേറ്റ്ലി ഇപ്പോഴും ഈ ഇല്ലീഗൽ റിക്രൂട്ട്മെന്റ് ഒത്തിരി 20 വിസ നടക്കുന്നുണ്ട്. ഇന്ത്യൻ എംബസി അറിയാതെ ഒത്തിരി ആൾക്കാർ ഇപ്പോഴും വരുന്നുണ്ട് ഇവിടെ. അപ്പൊ അവരുടെയൊക്കെ കേസിൽ നമുക്ക് ഈ പറയുന്ന കാര്യങ്ങളൊന്നും ഇംപ്ലിമെന്റ് ചെയ്യുന്നതിന് ബുദ്ധിമുട്ടുണ്ട്.
ഓക്കെ. ഈ കുവൈറ്റില് ഈ 20 വിസ ഹോൾഡേഴ്സിന്റെ അവർക്ക് ഒരു ഇഷ്യൂ വന്നു കഴിഞ്ഞാല് ഇമ്മീഡിയറ്റ് റിസോർട്ട് എന്ന് പറയുന്നത് ഇപ്പോഴും എംബസി തന്നെ. So they will intervene and provide whatever required.
ഇതിനകത്ത് ഒരു പ്രായോഗിക പ്രശ്നമാണത്. എന്ന് പറഞ്ഞാൽ ഇപ്പം നമ്മൾ ഒരു വീട്ടിനുള്ളിൽ താമസിച്ച് ജോലി ചെയ്യുന്ന ഒരാളെ സംബന്ധിച്ച് ഫിസിക്കലി വെളിയിൽ പോയി ലോക്കൽ പോലീസ് സ്റ്റേഷനിലോ അല്ലെങ്കിൽ ഹ്യൂമൻ റൈറ്റ്സ് കമ്മീഷനിലോ ഒന്ന് പോയി പരാതിപ്പെടാനുള്ള പ്രായോഗികമായ സാധ്യതകൾ ഇല്ല. അപ്പം ഏറ്റവും എളുപ്പത്തിൽ ചെയ്യാവുന്ന ഏറ്റവും അവൈലബിൾ ആയിട്ടുള്ള ഓപ്ഷൻ എന്ന് പറയുന്നത് എംബസിയുടെ ഹെൽപ്പ് സെന്റർ നമ്പറിൽ വിളിക്കുക എന്നുള്ളതാണ്. വിളിച്ച് കംപ്ലൈന്റ് രജിസ്റ്റർ ചെയ്യുക. പിന്നെ നേരിട്ട് എംബസിയിൽ എത്തിപ്പെടാന്നുണ്ടെങ്കിൽ എപ്പോഴും നല്ലത് തന്നെ. അതല്ലെങ്കിൽ പോലും ഒരു കംപ്ലൈന്റ് രജിസ്റ്റർ ചെയ്താൽ എംബസി എന്താ ചെയ്യാന്ന് വെച്ചാൽ എംബസി ഈ എംപ്ലോയറുമായിട്ട് കോർഡിനേറ്റ് ചെയ്യുന്നേ ഉള്ളൂ. കോർഡിനേറ്റ് ചെയ്യും, അയാളെ വിളിച്ചു വരുത്തും, ആയിട്ട് കാര്യങ്ങൾ റിസോൾവ് ചെയ്യാൻ നോക്കും. അതാണ് എംബസി ഒരു കൺസിലിയേഷൻ പ്രോസസ് ആണ് ചെയ്യുന്നത്.
വേറൊരു ക്വസ്റ്റ്യൻ എന്ന് പറഞ്ഞു കഴിഞ്ഞാല് ഇപ്പം ഒരുപാട് കമ്പനികൾക്കെതിരെ ഇപ്പം 10-12 വർഷത്തെ ഇൻഡെംനിറ്റി ഒക്കെ ക്ലെയിം ചെയ്തിട്ടുണ്ട്. കമ്പനികള് ഫിനാൻഷ്യൽ ക്രൈസിസിലാണ് അവർ പൂട്ടിപ്പോയിട്ടുണ്ട്. അപ്പം നമുക്കറിയാം എംബസി ഇന്റർവീൻഡ് ഇൻ ദാറ്റ് ആൻഡ് എംബസി കേസസ് ഫയൽ ചെയ്തിട്ടുണ്ട്. And they are waiting for that. But several people in India, they are asking whether what is the progress on that, because if any considerable progress has happened in that. Angana question vandittund.
See, the issue here is embassy is just coordinating the process. One of the lawyers in the embassy panel will actually be conducting the case. Okay. So naturally, the progress updates can either be obtained through embassy from the lawyers, or if we have the direct contact number of that particular lawyer, we can coordinate directly with them. Or alternatively, if we have the case number, we can also check it through online.
Okay. Fine. Some other question is consumer law related questions are there. Does Kuwait has a consumer redressal forum? What are the services available? Any hotline or anything is available?
See, of course, Kuwait has, surprisingly, Kuwait has passed a consumer protection law somewhere in 2014. And Ministry of Commerce and Industry has a consumer protection, consumer redressal, complaint redressal department. 135 is the contact number. So as a hotline, we can call 135 and register the complaint. But there is no separate consumer courts as such in India, in Kuwait. So in case we need to file a case, we have to file it through the normal commercial courts.
Okay.
But the consumer redressal department is the first line of defense, first line of redressal mechanism. So we can approach them, we can call them, and we can file a complaint.
Okay. Another question is from one of, I think he is a wholesale dealer. He just want to ask something. What he says is that as per the Kuwait law in Kuwait, we have to, that means the dealers or the merchant have to return any goods sold within 14 days. And he is citing some examples. Some companies are even, look into the matter if the carton is open and returned. And some the mobile boxes are open, they will not accept jewelry, the same situation and all. His question is that some people buy bulk quantities from him, and maybe before the expiry of 14 days, they may come and return some of the items. So what is, what he can do for this? Because that may end up in a big loss to him. That is his concern. So he inquired about that. If any such law is there that is restricting, that is the 14 days period is a mandatory requirement, so that within that period, the dealer or the merchant has to take it back. Such a law is there or no?
Yeah, see, there is a law, the Article 10 of the Consumer Protection Law clearly stipulates that requirement.
Okay.
But at the same time, there are exemptions under the same provision, which says that, okay, this is the thumb rule, this is the default rule, 14 days window is available to return, except certain items are excluded also, such as jewelry, such as, for example, undergarments, which is, and the garments which is getting in contact directly with the skin, perfumes. Also, that's what I remember. There are few items. There is a clear exemption of few items which is not coming under this 14 days window.
Yeah.
So those items can be rejected. Those items cannot be. But even those items, they are giving a 24 hours window.
Okay.
Not like 14 days, but 24 hours window is available, but not for the undergarments and all, but all other items.
So
Jewelry.
this is applicable to both a retailer and a wholesaler, right?
See, wholesale is a back-to-back issue, because the wholesaler is not coming in contact with it's a B2B business. Wholesaler is not coming in contact with the consumer or the customer. So basically the retailer is in front end. So retailer has the responsibility, but retailer can apply this back-to-back to the wholesaler.
Yeah. Okay. Fine. Then another question is, actually the question is not so clear. Anyway, I'll try to figure out, and if you, let us see. There are many travel agents in Kuwait who commit certain services, but they don't deliver as they promise. I think it is a sufficient, service deficiency complaint. I think this is what he is looking for. If such a situation is there, just like a commercial matter, we have to approach that, or any other mechanism is there?
No, there is a separate mechanism.
For travel agents and
yeah, there is a separate mechanism for travel agents and airlines related complaints. The regulator or the authority responsible for this area or this line of business is the Kuwait Director General of Civil Aviation, Kuwait DGCA we call. So if there is a complaint, or there is a deficiency of service, or if a consumer or the passenger has to raise a complaint against a travel agent, he can always go to the Kuwait DGCA website. There is a provision for registering online complaints, or he can go to the Kuwait International Airport, the old airport, and the Kuwait DGCA office is next to it. So they can personally go and complain also. But it depends on the nature, because if it is related to a ticket issued by a travel agent, once the ticket is issued, the issue is transferred to the airline, who is going to deliver that service.
Okay, fine. Some questions are from the criminal law. Let's see. A person is arrested and in jail for an offense of bribery for obtaining a driving license. His driving license is cancelled now, and he was called for investigation and put in jail. So he is in jail now. How can he get bail? What would be the next course of action?
See, the first answer, preliminary answer, is to appoint a Kuwaiti national lawyer who is licensed to handle these kind of cases and who can go and get him on bail. But I have to tell you, this particular case, this particular license bribery cases, nowadays what we have seen is they have a summary proceedings, and hardly in 14 days these people will be deported. Once they arrest them, even they don't give bail, they don't release him on bail. They will go to the public prosecutor, they get him into the custody, maybe they will extend the custody one more time, and then they will complete the process, and the undersecretary will immediately issue the deportation order, and they deport. I have seen 3 or 4 cases in recent times wherein they have deported in maximum in 20 days.
Okay. Okay.
So it's a very critical issue. Many people are not aware of the seriousness of this matter. They will get a very normal call from the NIABA, the Public Prosecution or the Investigation Agency, saying that we need to verify certain things with you. Please come to this so and so place. So please be careful. If you have done any mischievous activities related to the license, you have to be careful. See, even we think it's a very simple thing, but it's not simple. Because I can say that many people think we can still go and get license through WASTA, but then these kind of fringe issues will come.
Yes. So that there is a room for a sub question to that. So what are the things to be looked into if a person is called for investigation?
No, naturally we should know. We should first ensure that we have not committed any crimes. This is first and most important thing. But if we have an idea, or if for what reason we are being called, you can always ask them. Maybe they will give you a very brief background about the issue to be interrogated. Then it's always better to, once we have an idea about the issue, then it's always better to go with the Kuwaiti lawyer. So he can at least talk to them, and then at least if he is kept in custody, he can come out and get him, try to release him.
Okay. So, I mean, getting a bail from a Kuwaiti court, I mean, only through a national we can.
Only Kuwaiti national lawyers can do. See, this I have been always telling our friends. See, once you are arrested in a case, for example, a drunken driving case, then you don't need to go for WASTA. You directly approach a lawyer. He can bail you out, and he can conduct the case and release you. Most of the cases, what happens is somebody will interfere and brings a WASTA and pays a hefty sum. What he's doing is he's just paying a 50 kd, 100 kd bail bond and just releasing him. This is a normal process. Even if the WASTA note comes, still you can get a bail by yourself also. Then people think, oh, a case is all gone, everything is dropped. It's not like that. Once your blood sample is taken, case will be there, and you need to be extremely careful. It's always better to engage a lawyer and defend it. Otherwise, you will get finally an order for deportation, jail sentence, everything will be there. So that point in time, you cannot go back and correct it. So you need to do it from the first beginning itself.
Okay, fine. So what should an expert do when his car met with an accident and a passenger third party injured or died?
The first thing, immediately upon happening the accident, you should call 112, report the matter, arrange the ambulance, arrange the people, the guy to victim to send the hospital. This is first thing to do. Then police will arrive. They will interrogate. They will make a report. And if it is not a death case, you will be released. If it is a death case, probably you will be kept at the station until they confirm the cause of death.
Okay, fine. There are frequently we are getting fake calls. You might have also received several types of calls from MOH asking for the details, asking for the OTP. Even some people are, giving the OTP and end up in big trouble and losing money. And if in such situations, if a person is losing his hard-earned money, is the bank is liable for that in that situation?
Yeah. See, this is a very common thing happening now. Even I used to get calls in a month at least one time. But now I play with them saying that I am from the MOI, so I'm monitoring you. Then they immediately cut the call and go. So it's very simple. Once the moment you take the call, you will have an intuition. You will know that this is not correct, because most of the time these numbers from which you are getting a call are not official numbers. And at the same time, the most important point is none of the authorities will ask you for OTP or any such personal details. Repeatedly, banks and authorities are issuing clarification on this thing, and unfortunately, even educated people are falling prey to these kind of tricks. Recently, one guy lost around 5,000 KD because he has given the OTP. So this is quite unfortunate. People should be aware that these kind of calls should not be entertained. Sometimes you are even getting calls from outside of Kuwait. So do not entertain such calls. Even recently, people started calling as if they are calling from Indian embassy, saying that your passport details are fake or you will be detained when you arrive in India. People got panic and then start giving everything. There is nothing. If you have received such a call, you can always verify the same with the Indian embassy. And first of all, Indian embassy has issued many circulars clarifying that no such calls will be made by the authorities in India or even from the Indian embassy. So please, you are not obligated to do that.
Okay.
And also the most important fact is, if you have given OTP and you lost money, bank has zero liability, because banks will directly say that this is your problem.
Okay, fine. So now the time is 8 p.m. I mean, do you mind continuing some more time, because we need to cover some more questions. So can you spare some more time? I'm asking to you, Mr. Rajesh.
I am okay. I'm with you. I'll be with you
Okay.
until
Okay.
you
Thank you.
exhaust.
Thank you.
I have
Thank
no
you.
problem.
Thank you very much.
I'll be most.
Great.
I enjoy this session
Oh,
actually, so it's
okay.
okay.
Okay, fine. So then let's go to the company law section. A few
Mhm.
questions are in that section as well. We received
Okay.
some questions.
Mhm.
How do you think the law reforms for companies and commercial establishment in Kuwait, will it be more business friendly for expats? It's a general question.
Yeah, Kuwait typically ranks the mid-range for ease of doing business in the world or even in GCC. It's not bad, it's not perfect, but it is comparatively well established. Business-friendly laws are available. The most important issue is any investor or an expat who intends to do business should consult properly and take necessary measures, protective measures, while investing and doing business in Kuwait. Most of the cases, in my experience for last 25, 26 years, most cases, these issues are happening because of our ignorance or our laziness. Some people come and consult with me because I'm doing this corporate consultancy actually on a regular basis. People come and discuss and then they go back. Then an issue comes, they come back. So the most of the cases, what they are doing is, the most secure way of doing business is to establish a WLL company with 4951 partnership with single management for the foreigner or the investor. But most of the cases, people, to avoid this process and investing few KD, 100 KDs in the beginning, the Kuwaiti will say, okay, I can give my license, you can use it. You are, like my partner, I don't cheat you. And then he started leasing the license and doing business. The important point is, as per law, he is the only owner. He is the 100% owner of that business, the Kuwaiti. So we cannot blame tomorrow the Kuwaiti partner. Suppose he takes over and he kicks the foreigner out, because he paved that, he created that situation. He should not have done that from the beginning. So this is a basic thing, but the laws are very, very clear. The laws are uh, protecting the interest of the investors, but unfortunately, if you refuse to go and comply with the provisions, nobody can help. But don't blame the system. System is okay.
Okay.
Many of the successful Indian business, if you look at them, they're all okay.
Okay, fine. So, Mr. Rajesh, do you have a paper, a workbook, and a pencil with you now? Because there is a
What is it?
problem is coming.
What is that?
So I'm a partner having 49% shares, and I'm the manager of a company.
Mm-hmm.
I want to open a new company with my first company as 51% partnership in the new company. So far clear?
Yeah.
And me being again a manager or a partner of 49%. Okay. So will this have any issues in taxes now or in future? will it be called a local Kuwaiti company? Also, kindly
Actually,
shed some light on forming a company with another company being a partner.
actually, I'm surprised to see this
Interesting.
question because this structuring I have introduced first time in a few years back with some of my clients, and nobody believed it actually.
Yeah.
So it is possible, it is workable situation, and whoever is interested to know more deep, because it's a specific personal issue, we can he can always call me. I can give him the details. But it's a workable, it's a doable thing, and it will be considered as a local Kuwaiti company. And for tax exposure, as long as of now, as of today, the foreign partner is individual, not tax exposure. Only when a foreign corporate entity become the partner of the company, a tax exposure issue will come.
Okay, fine. So, I mean, another thing is that what are the precautions taken by an investor in starting a company? You can also explain briefly how a company can be started.
Okay.
Is there any provision to protect the rights of an expat partner? Because you know very well that there will be some supplementary or side agreements to protect the interest of the parties. Is that legally acceptable, and will that give any protection to the foreign partner?
See, basically, the best way of doing business is to do it legally available by forming a legally available format, which is, for example, if a foreign partner comes in and to do business, the best option available to him is to form a WLL company, which I have explained earlier, with 14 and 51, and with single management for the foreign investor. It is easy to establish. I am doing it in 3 to 4 weeks time. It's not a complicated process. Many people think it's a very complicated, expensive process. It's not like that. Especially with the reforms introduced by the Kuwait Ministry of Commerce, it's very smooth process. It can be done in maximum in 4 weeks. So once you have 49% and single management, you are almost controlling the entire process. You will be the driver, you will control the whole thing. And then to protect your investment, you can have a side agreement. See, the side agreement will only protect your investment part. We cannot dilute the shareholding because that is not approved by the laws. So, but the investment investment part we can structure it. Is easy to structure. We are structuring it also, and the courts of Kuwait also look into the beneficial rights of the real investor.
Yeah.
So it can be done. It is not an issue.
Fine. Okay. Some questions from the personal law side. It's noted that the domestic violence are on rise among Indian expats. How do we handle this issue? Is there any domestic violence, act or any forum there?
No. See, the domestic violence, any violence is not permitted under the laws of the country. So, in case of a domestic violence, the first line of action is to go and complain to the local police station, where the wife lives with the husband. There, she can go and file a complaint to the police station. Naturally, the police will call the husband, and then sometime they will give him a warning, saying that if you do repeat it, you will face consequences. Most of the cases, especially the Indian expats, they don't go beyond that level. Or if he continues, what she can do is she can live separately and claim for maintenance, alimony, and then she can live in a separate house. So that provision is available here. Or she can even file a case in India against him for the domestic violence. 498A proceedings are there, which is criminal now, which is a very serious thing. And many cases actually, I can see it's misused also. Even for normal divorce cases, to support the divorce, 498A proceedings are initiated, which is actually a misuse. Same like many other protective laws, this law is also misused, unfortunately, by our own brothers, lawyers. They are using this as an additional supporting thing. But otherwise, it can be redressed effectively in Kuwait. Even embassy is involving in some of the cases, because embassy has a conciliation role, but still they can use other techniques, because in one of the cases, in my knowledge, embassy involved in a domestic violence case wherein the husband was adamant. Finally, embassy said your renewal of passport will not be done. So finally, he handed over the passports of the wife and the kids, and they travel back. So these kind of things, there are different avenues available.
Okay, fine. I have a sub question to that. I mean, can the next door neighbor of a fighting husband and wife file a complaint of public nuisance against them?
They can file a complaint to the police station, but I don't know whether the police will involve seriously in that kind of cases, but definitely he can.
Okay, good. Can expats approach Kuwaiti courts to dissolve their marriage? If an order is passed by the Kuwait court on that dissolution of marriage, whether that is executable there or that is valid in India?
See, this is a very tricky situation. If the divorce, of course, first thing the expats can approach, but the problem is, if we are approaching through the normal Sharia courts, the normal Sharia courts also, if we are agreeing to the jurisdiction, they will proceed with the Sharia law also. But if you can also, you can choose the secular court, which will apply the personal law of respective parties, which is going to be expensive and long process, because the local Kuwaiti lawyers are not familiar with the foreign law proceedings. The major issue is, suppose the divorce is obtained not based on mutual consent, then it will be difficult to be executed, or it may not be executed in India. I'm talking about the Indian scenario, because there is no reciprocity between Kuwait and Indian courts. So if it is a mutual consent divorce obtained in Kuwait by following the same process of Indian system, then that can be considered as a final conclusive order as far as the husband and wife is concerned, because mutual consent orders are not normally permitted to be challenged, even in India, same situation. But all other cases, divorce orders obtained from Kuwait courts may not be considered as valid and binding if the other party is contesting it in India.
Okay, fine. Another question is related to labor issue, not directly labor issue. Anyway, question is that is there any period of limitation to file a case against employer who for indemnity benefit for an expired person by his family?
Yeah, see, any labor indemnity cases, labor 1 year is actually from the last day of employment. So if it's an expired party's case, it's the date of expiry can be considered as the last day of his employment. That's 1 year.
Fine. A few more questions. That is, if can an immigration officer charge fine for extra luggage? What is the reasonable procedure one can follow in case of excess luggage?
Immigration officer charging excess baggage?
Immigration officer, I think that the airline officer, he may be asking, that question in that way.
Because immigration officer has nothing to do with the luggage.
Exactly.
So I don't know. Maybe because it depends on each airline's baggage policy.
There are baggage policies.
Because once you purchase the ticket, baggage allowance is already indicated in the ticket conditions, or he can go to the respective airlines website where conditions of carriage will be there and baggage allowance will be there. And if most of the airlines follow the peace concept now, so it's easy to understand. Or if he is purchasing from the travel agent can also clarify that.
Fine. So next question is regarding a POA, power of attorney, and what is the procedure of legalizing power of attorney in Kuwait?
Okay, if power of attorney is to be issued in Kuwait and to be used in Kuwait, then the individual the executant has to go to the Ministry of Justice Notarization Department. For example, he can go to the Ministry complex in city. there is a notarization department. He can go there with his original civil ID and either copy of the civil ID of the party in whose name the power of attorney is to be issued. And now revised fee is now, I believe, 10 KD. If you pay 10 KD, they will make the power of attorney. You just explain to them the requirement. So there is a standard format for each power of attorney. So they will make the power of attorney in short, maybe half an hour. You can finish that, and then there is no further legalization process are required to use that power of attorney in Kuwait. But if somebody is in India, for example, and he wanted to give a power of attorney to somebody in Kuwait to do something on his behalf in Kuwait, then process is different. He has to execute a power of attorney on a stamp paper. Right now, 500 rupees stamp paper, and then notarize it with the public notary. Then get it attested by the Ministry of Foreign Affairs and then by the Kuwait Embassy in India. After that, send the original to Kuwait, translate it into Arabic through an official translation office, get it attested by the Ministry of Foreign Affairs and Ministry of Justice. Then it's ready to use.
Okay. Is there any, just like in India, I mean, there are so many lawyers are given the authority of notarizing the documents or attesting the documents. I mean, does we have such a mechanism here in Kuwait, or there is only one department called a notary department?
This is also a repeated question I'm getting because many people are approaching me to attest their document. But you know, as a default rule, no foreign lawyer can attest a document as a licensed attorney in Kuwait. All foreign lawyers, irrespective of the nationality, they are all consultants or they are just advisors. The license to practice lawyers are only Kuwaiti lawyers, same like in India also. Only Indians can practice before the courts. So the licensed lawyers only can attest those documents as a lawyer, as an attorney. But if somebody is saying compelling it to be attested as a notary, there is no notary. There is no private notaries available in Kuwait, same like India. There is only notarization department at Ministry of Justice can attest that document, but they also have some restrictions. They may not attest a document which to be used outside of Kuwait. They will only attest document issued in Kuwait for the use of use in Kuwait.
Okay, right.
But I heard many of our colleagues, Indian lawyers, are doing it, but it is wrong.
Exactly. Yes. I mean, is there any latest updation regarding the customs law for carrying gold or electronic items to India?
The one update came recently is if you are carrying gold or cash worth more than 3,000 KD, you should report it, declare it while leaving Kuwait and even entering Kuwait.
Okay. I mean, do we have a data protection and privacy law in Kuwait for individuals?
Yes, there is.
There is.
Yes.
I mean, is promissory notes valid and enforceable in Kuwait? Who can issue promissory notes?
Promissory note regulation or condition for issuing promissory note by individuals have changed recently. Not recently, for some years before, because many people were misusing it. So before it can be criminal proceedings can be initiated also as an negotiable instrument, same like check. It was considered equal to check, but lately no, they are not considering it as any criminal action is possible in case of a violation of promissory note. And also promissory note should follow exact format of it, otherwise it has no meaning. So individuals issuing promissory note in a way they like, it cannot be called as a promissory note. So ideally, if somebody wants to secure their payment, they should go to the Ministry of Justice and they can get a debt declaration from the ministry signed by the debtor.
Okay, fine. I have another question, but that is, I try to figure out what exactly he's looking for, but we need more details to answer that question. Let's see what we can provide in this.
Okay.
It's regarding a defamation or filing of a defamation case. how long can it go? What's the penalty that can be expected if a person found guilty under defamation?
I cannot predict the period of completion. It's largely a litigation. It can be, I don't know, maybe 6 months to 1 year, but no, precise time can be given. Even precise sentence also cannot be, because it depends on the the factors to the specific case.
Correct. I think with this we can conclude that. I mean, one thing you can, for the last question is there, I think you can explain in Malayalam as a concluding little bit, explain on the indemnity accrual during the service period, അതുപോലെ തന്നെ overtime eligibility in weekdays, weekends and holidays. I think you have remarked already this one. If you can go in further details into that, it would be nice in Malayalam. Maximum
ഇൻഡെമിനിറ്റിയുടെ കാര്യം ആദ്യം മറ്റത് എനിക്ക് നമ്മൾ പറഞ്ഞിരുന്നു. നാഷണൽ ഡേയ്സിലും ഹോളിഡേയ്സിലും ആണെങ്കിൽ ഡബിൾ ദ പേയ്മെന്റ് ആണ്. നോർമൽ ഇതിലാകുമ്പോൾ 25% എക്സ്ട്രാ വരും. അല്ലാത്ത ദിവസം പിന്നെ അഡീഷണൽ ഒരു നാഷണൽ ഡേയ്സിൽ അല്ലെങ്കിൽ പബ്ലിക് ഹോളിഡേയ്സിലും ഫ്രൈഡേ വർക്ക് ചെയ്ത ഒരു അഡീഷണൽ ഓഫ് ഡേയും കൂടി എലിജിബിൾ ആണ്. അതിനൊരു ശരിക്കും ഇഫ് യു ഫോളോ സ്ട്രിക്ട്ലി ദർ ഇസ് എ മാക്സിമം ക്യാപ്പ് ഓൾസോ. ഹൗ മച്ച് ഓവർ ടൈം യു ക്യാൻ ഡു.
Yeah, you can say it in Malayalam.
Sorry, ഒരു ഓവർ ടൈം ചെയ്യുന്നതിനും ഒരു പിന്നെ ലിമിറ്റ് ഒക്കെ ഉണ്ട്. പലപ്പോഴും കമ്പനികൾ അതൊന്നും ഫോളോ ചെയ്യുന്നില്ല. ലോ പറയുന്നതിൽ നമുക്ക് പറയാൻ പറ്റും. ഡെയിലി 2 മണിക്കൂറാണ് മാക്സിമം പെർമിറ്റഡ് ഓവർ ടൈം. ഓവർ ആൻഡ് അബോവ് 8 hours. അതാണ് അതിന്റെ ഒരു ലീഗൽ സിസ്റ്റം. ബട്ട് മോസ്റ്റ് ഓഫ് ദ കമ്പനീസ് എല്ലാവരും അതൊന്നും അല്ല ഫോളോ ചെയ്യുന്നത്. എംപ്ലോയീസും റെഡിയാണ് കൂടുതൽ ഓവർ ടൈം ചെയ്യാൻ. അതുകൊണ്ട് പിന്നെ അതൊരു ഗിവ് ആൻഡ് ടേക്ക് സംഭവമായിട്ട് പോയിക്കൊണ്ടിരിക്കുന്നു. ഇൻഡെമിനിറ്റിയുടെ കാര്യം പറയുവാണെങ്കിൽ, ഇൻഡെമിനിറ്റി നമ്മൾ കാൽക്കുലേഷൻ കമ്പോണന്റിൽ വലിയ വ്യത്യാസമൊന്നും പഴയതും പുതിയതുമായിട്ടുള്ള ലോയിൽ വന്നിട്ടില്ല. ഇപ്പോഴും ആദ്യത്തെ 5 വർഷം ഉള്ള ഇൻഡെമിനിറ്റി, ഒരു ഇലസ്ട്രേഷൻ കേസ് എടുക്കാമെങ്കിൽ ഒരു 7 വർഷം സർവീസ് ഉള്ള ഒരു എംപ്ലോയിയുടെ ഇൻഡെമിനിറ്റി കാൽക്കുലേറ്റ് ചെയ്യുന്നത് ആദ്യത്തെ 5 വർഷം ഈച്ച് കംപ്ലീറ്റഡ് ഇയേഴ്സ് 15 days ആണ്. അപ്പൊ 15 days കാൽക്കുലേറ്റ് ചെയ്യുന്നതും ഹാഫ് മന്ത് കാൽക്കുലേറ്റ് ചെയ്യുന്നതും വ്യത്യാസമുണ്ട്. 15 days എന്ന് പറയുമ്പോൾ ആദ്യത്തെ 5 വർഷത്തിന് അയാളുടെ മൊത്തം എലിജിബിലിറ്റി എന്ന് പറഞ്ഞാൽ 75 days ആണ്. അപ്പൊ ആ പീരീഡിന്റെ ഇൻഡെമിനിറ്റി കാൽക്കുലേറ്റ് ചെയ്യുന്നത് ലാസ്റ്റ് ഡ്രോൺ ടോട്ടൽ മന്ത്ലി സാലറി 26 കൊണ്ട് ഹരിച്ചിട്ട് 75 കൊണ്ട് ഗുണിച്ചാൽ കിട്ടുന്നതാണ് ആദ്യത്തെ 5 വർഷത്തെ എലിജിബിലിറ്റി. അതിനുശേഷമുള്ള ഇപ്പൊ 7 വർഷം എന്ന് പറഞ്ഞുകൊണ്ട് അതിനുശേഷമുള്ള ഓരോ വർഷം കംപ്ലീറ്റ് ചെയ്തതിനും ഓരോ മാസത്തെ ശമ്പളമാണ്. അത് ഡേയ്സ് അല്ല, അത് ടോട്ടൽ മന്ത്ലി സാലറി എത്രയാണോ അതാണ് കണക്കൂട്ടുന്നത്. അപ്പൊ ഇയാളുടെ ഒരു കേസിൽ 75 days സാലറി പ്ലസ് 2 months സാലറിയാണ് അയാളുടെ ഇൻഡെമിനിറ്റിയുടെ എലിജിബിലിറ്റി. ഇനി ഇത് റിസൈൻ ചെയ്യുന്ന കേസിലും ടെർമിനേഷന്റെ കേസിലും എക്സ്പയറി ചെയ്യുന്ന കേസിലും ഒക്കെ വ്യത്യാസമുണ്ട്. അപ്പൊ 7 വർഷം ജോലി ചെയ്ത ഒരാളെ സംബന്ധിച്ച് അയാൾ റിസൈൻ ചെയ്യുന്നു, എംപ്ലോയി ആണ് റിസൈൻ ചെയ്യുന്നതെങ്കിൽ ഈ 7 വർഷത്തെ ഇൻഡെമിനിറ്റി നമ്മൾ ഈ പറഞ്ഞ പോലെ കാൽക്കുലേറ്റ് ചെയ്തതിനു ശേഷം അതിനെ 3/4 കൊണ്ട് മൾട്ടിപ്ലൈ ചെയ്യുമ്പോൾ കിട്ടുന്നതാണ് അയാൾക്ക് കൊടുക്കേണ്ട നെറ്റ് ഇൻഡെമിനിറ്റി പേയ്മെന്റ്. അതേസമയം അയാളുടെ സർവീസ് എക്സ്പയർ ആയി, അല്ലെങ്കിൽ അയാൾ റിന്യൂ ചെയ്യുന്നില്ല, അല്ലെങ്കിൽ അയാൾ എംപ്ലോയർ ടെർമിനേറ്റ് ചെയ്യുന്നുവെങ്കിൽ ഈ ആദ്യം പറഞ്ഞ ഫുൾ എമൗണ്ട് അയാൾക്ക് കിട്ടും. പക്ഷെ ഇയാള് 10 വർഷം കംപ്ലീറ്റ് ചെയ്തതിന് ശേഷമാണ് റിസൈൻ ചെയ്യുന്നതെങ്കിൽ ഒരു വ്യത്യാസവും ഇല്ല, ഒരു ഡിഡക്ഷനും പാടില്ല, ഫുൾ ഇൻഡെമിനിറ്റി അയാൾക്ക് കാൽക്കുലേറ്റ് ചെയ്ത് കൊടുക്കേണ്ടി വരും. ഇതാണ് ഇൻഡെമിനിറ്റിയെ സംബന്ധിച്ചുള്ള കാര്യം. പിന്നെ എത്ര ലീവ് അക്രൂഡ് ലീവ് അന്ന് ബാലൻസ് ഉണ്ടോ അതിന്റെ ഫുൾ സാലറി, അത് റിസൈൻ ചെയ്താലും ടെർമിനേറ്റ് ചെയ്താലും ഒരു വ്യത്യാസമില്ല, ലീവ് സാലറി ഫുൾ ആയിട്ട് കൊടുത്തേ. ഇതാണ് അതിന്റെ. പിന്നെ ലീവിന്റെ കാര്യത്തിൽ ഒരു ചെറിയ ക്ലാരിഫിക്കേഷൻ ഞാൻ അന്ന് നേരത്തെ പറഞ്ഞില്ല, പലർക്കും അബദ്ധം പറ്റുന്ന ഒരു കാര്യം. ലോ പറഞ്ഞിരിക്കുന്നത് 2 വർഷത്തിൽ കൂടുതൽ ലീവ് അക്യുമുലേറ്റ് ചെയ്യാൻ പാടില്ല. അപ്പൊ പല കമ്പനികളും ലീവ് കൊടുക്കാറില്ല. അപ്പം എംപ്ലോയി വിചാരിക്കുന്ന എന്താ, ഇതെല്ലാം കൂടി അവസാനം ഒന്നിച്ച് കിട്ടും. പക്ഷെ അവരൊരു സ്ട്രിക്റ്റ് ലോ ഫോളോ ചെയ്ത് കഴിഞ്ഞാൽ അവർ പറയും ലാസ്റ്റ് 2 വർഷത്തെ അക്യുമുലേറ്റ് ചെയ്ത് മാത്രമേ തരൂ എന്ന് പറഞ്ഞാൽ നമ്മൾ ഷൂണിൽ പോയാൽ പോലും ചിലപ്പോൾ അത് നമുക്ക് അനുകൂലമായിട്ട് കിട്ടണമെന്നില്ല. അല്ലെങ്കിൽ പിന്നെ എംപ്ലോയർ ഒരു സ്റ്റേറ്റ്മെന്റ് എഴുതി ഒപ്പിട്ട് തരണം, ഇത് ക്യാഷ് ഇക്വലന്റ് ആയിട്ട് കൺസിഡർ ചെയ്യുന്നു, അവരുടെ ജോബ് റിക്വയർമെന്റ് കൊണ്ടാണ് ലീവ് കൊടുക്കാത്തതെന്ന് പറഞ്ഞാൽ അവർ നമുക്കൊരു സ്റ്റേറ്റ്മെന്റ് തന്നാൽ നമുക്ക് അത് വെച്ചിട്ട് എന്തെങ്കിലും ക്ലെയിം ചെയ്യാം. അല്ലാത്ത ഒരു സമയത്ത് നമുക്ക് 2 year അക്രൂഡ് ലീവിന് അപ്പുറത്തേക്ക് ക്ലെയിം ചെയ്യാൻ പറ്റില്ല. അതുപോലെ ഇൻഡെമിനിറ്റിയുടെ ടോട്ടൽ ഇൻഡെമിനിറ്റിയിൽ ഒരു സീലിംഗ് ഉള്ളത്, നമ്മൾ എത്ര വർഷം വർക്ക് ചെയ്താലും വേണമെങ്കിൽ 18 months വെച്ച് മാക്സിമം സാലറി തന്ന് നമുക്ക് ഇൻഡെമിനിറ്റി ക്ലോസ് ചെയ്യാം. അങ്ങനെ ഒരു പ്രൊവിഷൻ ലോയിലുണ്ട്. പക്ഷേ ചില എംപ്ലോയേഴ്സിന് ഡിപ്പെൻഡിങ് ഓൺ എംപ്ലോയേഴ്സിന് അത് വേവ് ചെയ്യാം, എംപ്ലോയേഴ്സിന് അത് ഓപ്പൺ ആയിട്ട് തരാം. പല കമ്പനികളും അങ്ങനെ കൊടുക്കുന്നുണ്ട്. പക്ഷേ വേണമെങ്കിൽ അവർക്ക് അങ്ങനെ റെസ്ട്രിക്ട് ചെയ്യാം. ഇതാണ് ഇൻഡെമിനിറ്റിയെ സംബന്ധിച്ചുള്ള ഒരു ബേസിക് ആയിട്ടുള്ള കാര്യം.
Okay. I think with this we can conclude. I think we have gone 30 minutes additional time. Anyway, thank you very much. If any further clarification requires or any of the questions, I mean,
അത് നിങ്ങൾ കളക്ട് ചെയ്ത് കഴിഞ്ഞാൽ നമുക്ക് 1-to-1 ആയിട്ട് ആർക്കെങ്കിലും ക്ലാരിഫിക്കേഷൻ ആവശ്യമുണ്ടെങ്കിൽ I will be happy to give that. There is no issue. For people who need any private consultation, you can always contact PPF and then I will try to assist.
Fine, that's great. Thank you very much, Adv. Rajesh. Over to you, Prashant.
Thank you. So I'll just move on to the concluding part of the session, which is my vote of thanks. Good evening, everyone. On behalf of PPF Kuwait, I would like to extend a heartfelt vote of thanks to each and every one of you for joining us for this legal webinar. We are truly grateful for your presence and engagement throughout the session. Your valuable feedback and participation have made this event a greater success. I would also like to take this opportunity to thank our speaker, Advocate Rajesh Sagar, who took the time to share his knowledge and insights with us today. The presentation, the Q&A were informative, engaging, and most importantly, presented in a manner that was easily understandable by all. Our team has worked hard to make this webinar happen, and we are glad that it has been able to provide valuable information to all of you. Thank you for all the members, friends, and well-wishers of PPF Kuwait behind this event. Once again, thank you all for joining us and hope to see you at our future events. Have a great evening. Thank you, Advocate.
I think
with this
we are
we
closing.
conclude.
Thank you very much. Thanks for giving me an opportunity to meet you all and share our thoughts. Thank you. Thank you very much. And I hope we could conduct similar programs in future.
Thank you. Have a great evening, all of you.
Thank you. Thank you.